Hi, Steve Marlowe here from Marlowe Law Office, talking about debt collectors. Debt collectors are prohibited by the Fair Debt Collection Practices Act from doing a lot of stuff that they go ahead and do anyway. They're not allowed to harass, annoy, or abuse you. And as far as I'm concerned, any contact at all from a debt collector pretty much qualifies as harassment, annoyance, or abuse. They're prohibited from calling you when they know that you're represented by an attorney. Clients of mine often receive something called a creditor script, which is a list of things that they can say to a creditor who's called to prohibit the creditor from calling back, with my name, my address, my telephone number, and my email. Sometimes this stops the creditors, other times it just ticks them off and they call and harass you more. Creditors are not allowed to harass debtors at their place of employment after being advised that such contact is unwelcome. Oftentimes, credit collectors pretend to be attorneys or police officers. They're not allowed to do that. The law prohibits collectors from making threats to sue or garnish your wages unless they actually mean to do it and have the means to do it. They may not curse at you or use foul or profane language. The Fair Debt Collection Practices Act prohibits collectors from contacting your family or friends about your debts. They may not threaten to or display in any media false information about a credit report or about a debt that you owe in order to help collect that debt. If you want debt collectors to leave you alone, within 5 days of the initial contact from that debt collector, keep an eye on what they do. They have to, within that 5-day period, mail a notice of your right to dispute the debt. They also have to identify themselves and notify you at each point of contact that the communication is from a debt collector and that any information they receive will be used to collect the debt. If you're looking at this video, you've probably already dealt with this and have noticed that they often say, before they even talk to you, that they are debt collectors and that any information that they get will be used to collect the debt. That is just them covering their bases. Oddly enough and ironically, they will then go ahead and violate the rest of the Fair Debt Collection Practices Act after fulfilling that requirement of it. But don't be afraid. Many debt collectors are shady, and they don't want to be caught abusing debtors. They don't think they'll be caught. More and more creditors are outsourcing their debt collection to call centers in other parts of the world. Many of you have noticed that the collectors that call you barely speak English. If they do speak English, they may not even understand the cultural norms of the United States and may not understand the idiomatic phrasing that we use when we're discussing credit and debt. Foreign collectors usually have no clue as to the legal customs or the laws in America or Ohio, and these collectors routinely violate the Fair Debt Collection Practices Act. This means that you can turn the tables on your debt collectors. When a collector violates the Fair Debt Collection Practices Act, make sure that you keep good records, and then find an attorney who specializes in debt relief or collection defense. Your local bar association should be able to help you if you don't know one. Violations can cost debt collectors $1,000 per incident, plus reasonable attorney's fees. Remember, bankruptcy will stop all the calls. The automatic stay protects filers from any collection attempts from creditors. If you're facing bankruptcy or you're tired of the debt collection calls, go ahead and call Marlowe Law Office for a free consultation. We'll be happy to talk to you free of charge. The phone number here is 937-506-0505. That's 937-506-0505. Or you can click on the link at the bottom of your screen that says marlawoffice.com, and that'll take you right to our website and give you all the information that you need to contact us. Thank you very much.